welcome everybody. I actually had not planned on doing welcome and introductions. Judge Beater had wanted to be here and he went to the wrong location, so I'm going to wing it. I want to thank you all for attending. I think we've all been given an extraordinary opportunity to hear some amazing speakers. I will let you go ahead and read Jonathan Martinis' bio in the material. I just want to say I have had the opportunity to see him speak now a couple of times, including to all of our magistrate judges, and he is incredibly engaging and thoughtful and persuasive, which I appreciate. So for the time being, since I didn't prepare anything else, I'm going to go ahead and turn it over to Jonathan Martinis to get started.
I am not living up to that. So it's all downhill from there, folks. Sorry. Good morning. My name is Jonathan. I am so very honored to be with you today in this beautiful location, on this beautiful day to talk about something I think is a very beautiful thing. Something I think is the greatest advance for civil rights for people with disabilities and older adults since the Americans with Disabilities Act. And I'm talking about supported decision making, and it's what we're going to be talking about all day today. If you've heard of supported decision making, you've probably heard about it as an alternative to guardianship. I mean, after all, that's what the title of the presentation is, and that's true. But I hope that by the end of today, you're going to see something else about supported decision making, that it is a way to maximize people's life experiences, to improve their quality of life in all of the facets of their life, from literally birth through end of life. Supported decision making traces a through line through everything we do. But before I begin, two promises. Because it's true, supported decision making is an alternative to guardianship, but given that, you will never hear me say today or ever. I don't believe you're going to hear anybody speaking say today or ever that there should never be guardianships. That is not the point. You will never hear me say that. Of course, there are times when guardianship is appropriate. So that's promise number one. Promise number two, the things that you hear about today, the things I talk about, the things Judge and Amy talk about, don't require anything new. They're already consistent with your law and practice. They do not require new laws, new policies, new regulations, or new funding. In fact, it's my hope that you'll see the potential for cost savings and greater efficiency through implementing supported decision making. So those are my two promises. And now let's begin. Let me begin this way. I want to bust a myth. I want to tell you that you've all been lied to repeatedly. A bunch of lawyers in here probably know that already. You have been the recipient of what I think is one of the oldest and one of the most pernicious lies out there. And we need to dispel it right away, because no matter who you heard it from, and you heard it from parents and teachers and mentors and employers and speakers, it's a lie. There really are stupid questions. Here is one of them. What's your favorite right? Yeah, it's a pickup line at an ACLU convention, I know, but bear with me. What is the right that you treasure the most, that makes you the proudest to be an American, an Idaho, and a citizen? What is it, anyone? I'm not surprised. When I speak to people without disabilities and I ask that question, I get that same look you're giving me now. What do you mean favorite right? I don't think about my favorite rights. You know why, I think? It's the old joke. When my dad and I would go for a drive and we'd go past a graveyard and Dad would say, "Hey, John, how many people in that graveyard are dead?" And I'd be counting headstones, and Dad would say, "All of them." Same thing here. People without disabilities don't have to think about their rights because they have all of them. We have been raised understanding that we have fundamental rights, things like freedom of speech and elections and religion, life, liberty, and the pursuit of happiness. When I ask people with disabilities this question, they are coming up with answers. Because rights are critical to people with disabilities because they lose them so often. They treasure their rights because they know their rights are at stake. So think with me just this one time about your rights and realize how precious they are. And ask yourself this question now. All of those rights, speech, religion, association, and life, liberty, and the pursuit of happiness, do you know what they have in common? Choice. All of our rights come down to choice. Freedom of speech, the right to choose what to say. Religion, the right to choose how we worship. Elections, the right to choose the people who will govern us. Choice is what makes our rights worthwhile. It's why I say the right to make choices is the most fundamental one we have. Up on your screens, a quote from Jean-Paul Sartre. If you've read your Sartre, you know he's not the happiest fellow, but he gets it right. I am my choices. Everyone in this room is here because of the choices they've made all through their lives. Your choices, good and bad, silly and significant, have added up to you. You're here in this room having made the choice to come to this presentation. Really good one, by the way. Because of every choice you've made. When we make choices, we are setting our course. It is what clinicians call self-determination, another phrase people without disabilities don't have to think much about. But self-determination is just the right to make choices, the right to exercise that. Clinicians will say it is being a causal agent in your life. People who do things rather than having things done to them. When we are self-determined, we are the captains of our ship. We are individuals. And I say again, people without disabilities never think about that because that's just the way we are. For people with disabilities and older adults, self-determination is critically important. Here's why. We have 40 years of research, but it makes one unescapable conclusion. 40 years by people with way more initials after their name than me that say when people with disabilities, when older adults exercise their right to make choices, when they have the opportunity to make choices and control their lives are demonstrably better. Peer-reviewed studies repeatedly for 40 years. People with more self-determination tend to be healthier, more likely to be employed, more independent, better able to take part in and understand their care. So, stupid question number 2. Those rights that are so important to you, the ones that flow through our lives, are they worth anything if you're not allowed to exercise them? If I say, yes, sir, I understand you have freedom of speech, but you're only going to talk when I tell you to, and you're going to say what I tell you to say. Obviously, you have the right to vote if I take you to the polls, and then only if you pull the lever for the person I say. And yeah, community integration is a great thing, but you're going to live in my group home. At that point, are they rights? When we lose the ability to make choices and exercise our rights, are we even truly citizens? Well, that's exactly what we've been doing for 2,000 years. 2,500, I believe, actually, to people with disabilities and older adults. In fact, I stand before you in a law school, so this is hardly an embarrassing admission, but I stand before you a legal geek. I can tell you that in the Western world, the first time we wrote the laws down, Code of Hammurabi has us beat by millennia, but in the Western world, the first time we codified the laws was in something called the Justinian Code in ancient Rome. They wrote them all down for the first time. One of them said if you are feeble-minded, their words, you must have a curator put over you to make decisions for you and run your life. And we began our laws with that cultural, I call it, assertion, because that culture has flowed down for the last 2,500 years. The mother of our laws, Britain, had a law in feudal England that said if you are a person with disabilities, or as they charmingly put it, an idiot or a lunatic, you had to have a committee put over you to make decisions for you. That culture, that assumption that having a disability or being older equals the need to have someone placed over you has flowed down to America. We just call it guardianship. Now, before I begin on this slide, I want to repeat again, I'm not here to say that guardianship is evil or the guardians are wrong. Obviously not. But here is what I can tell you about our laws. I've looked at our laws in many states, including this one, and we will look at your laws. And guardianship works the same way in every state, essentially. If a judge decides that you can't make some decisions in your life, the judge is supposed to take away your right to make those decisions and give them to someone else. And even though in Idaho and most other states, the laws say that you should only take away those rights that you truly cannot exercise, the vast majority of guardianships, over 90% in one study, are full or plenary. They take away all rights. So in a very true sense, you cease to exist. That kind of guardianship, and that's what I'm here to talk about, overbroad or undue guardianships. Guardianships that take away your rights even though you can exercise them, or guardianships that take away more rights than you truly need to have taken away. Those are overbroad and undue guardianship. And when we see an overbroad or undue plenary guardianship, where you have lost all of your rights, and that gets empowered to you, that is what one law professor I know calls civil death. Because in the eyes of society and the law, you cease to exist. You cannot speak freely. You cannot travel freely. You cannot associate freely without your okay. And that is a dangerous thing. But as commentators have said for years, as long as the law recognizes it, it's going to happen. Here in Idaho, we see it in your laws. For people without developmental disabilities, generally older adults, when they are placed under guardianship, we see the guardian having the power and duty of a parent over a minor child. Pause for a second and think about the implications of that when you tell an adult that. For people with developmental disabilities, the law is a little broader, but when they say you're unable to manage your life, you can have a guardian put over you to manage all aspects of your life. And what that means, scholars have said time and time again, is that these guardians have tremendous power, even going into the most intimate areas of people's lives, where they go, what they do, who they see, whether they work or get health care, sometimes when they die. So that's dangerous. And we have to realize that just like we know for 40 years that self-determination is a good thing and the key to a better life for people with disabilities and older adults, the opposite is also true. When people lose their self-determination, when they lose control over their lives get worse. Back in 1975, Professor Deasy found that people who lose their self-determination feel helpless, hopeless, and self-critical. Rest of that sentence, they do not, quote, behave because they see no point in behaving. Others have found lack of ability to function, loss of interest in new activities. And I got to tell you, this ain't rocket science. If I tell you, ma'am, time and time again that you cannot do something, are you feeling particularly motivated to try? And in fact, what the studies show is that you'd be less motivated to try anything new. That's called learned helplessness. So that when we put someone in an overbroad or undue guardianship to correct a problem, we're often making it worse. I'm not here to say there should never be a guardianship, but I'm here to say we need to think about it. 2,500 years of culturally assuming or reflexively springing to guardianship is a very bad thing and contrary to decades of research. And it's a problem. It's a problem Congress has known about, and we've known about for over 30 years. This quote up on your screen is 30 years old. It's just as true now as forever. This quote from Congressman Claude Pepper, who chaired the Committee on Aging. They did the first national investigation of guardianship. Looked at guardianship laws, talked to guardians, talked to people under guardianship. This is pretty much literally page 1, paragraph 1. It bears looking at, because as I said, it's still true. Typical ward has fewer rights than the typical convicted felon. When people are placed under guardianship, particularly these overbroad and undue guardianships, what happens is you have someone else over their lives who can decide where they go, what they do, who they see, and sometimes when they will die and whether they get medical treatment. It is, in his words, the most severe deprivation of civil rights that can befall an American citizen. The rest of that sentence is short of the death penalty. So where do we go? Made a promise, going to keep it. I am not here to say there should never be guardians. In fact, of course, there are times when there should be guardians. When a person is so disabled or impaired they cannot take part in the decision-making process, of course, guardianship is appropriate. When someone chooses not to take part in the decision-making process and puts their health and safety at risk or that of others, of course guardianship's appropriate. If there are emergencies and no one around to help, of course at least a temporary guardianship is appropriate. Not my point to say there should never be a guardianship, but this is my point. There should never, ever be guardians just because you have X disability, reflexively, just because you're Y years old, because you need some help in your life. And the two that are frankly the most concerning to me, I hear them all the time, because that's the way it's always been, and because it's for your own good. Because it's for your own good. I hear that so much. Need to have a guardian for their own good. Think about that for a sec. Think about your lives. Show of hands, please. Who here has heard the phrase, relax, it's for your own good? And then had something good happen? That's right before the shot. I hear relax, it's for your own good. I'm looking for doors. And yet we hear it. I hear it all the time from parents. And I have to tell you, for years of doing this, I know one thing for sure. There are little to no mustache-twirling villains out there. Not many parents are saying, ha-ha, gonna seek guardianship and mess up my kid. No. No, the vast majority, 99.8% of people seeking guardianship are a loved one looking to protect someone. And that's what I hear. It's for their own good. If I don't get guardianship, my child might meet someone they shouldn't meet or sign something they shouldn't sign or do something they shouldn't do. They mean well. We mean well when we seek guardianship, and that's why it's so dangerous. That's why having a cultural assumption for guardianship is dangerous. Supreme Court gets it right. This is a Supreme Court decision that is 90 years old, and once again, just as true. Court said when we mean the most well is when we have to be the most careful. The greatest dangers to liberty lie in men of zeal, well-meaning but without understanding. I am aware it says men of zeal. Please note it's from 1928. Women had just gotten the right to vote 9 years before. The 9 old white guys on the court were apparently not aware that you could also have zeal. We've progressed. We can now say people of zeal, but this is absolutely true. When we mean well, when we take away rights with the best of intentions, I'm afraid you might have a bad relationship. I must protect my child from signing the papers. I must protect my child from doing the wrong things. We mean well, but we don't understand the consequences. We don't understand the dangers that come with taking away rights that we hold so dear and so fundamental that we don't even think about them. Well, I want you to think about them now, and I want you to realize the same things that you hear, the same things that I hear, man, they're well-meaning but dangerous. They might sign something they shouldn't sign. They might do something they shouldn't do. Well, can I get a show of hands from my audience again? Who here's closed on a mortgage? As anyone who's been through the early 2000s can tell you, and I am the mortgage crisis made flesh, I have closed many times, and I know the procedure quite well. I'm sure you do too. Let's look at it together. Here's how you close on a mortgage. You sit at a table, and you got sellers and lawyers and agents, and you got your own agent if you're smart. And my agent always had a stack of papers that high. And my agent handed me those papers time and again. You know what my agent said? Sign them. Who here didn't read them first like me? That's a bold admission, ma'am, but I want you to think about what you did. You put hundreds of thousands of dollars of your money and 30 years of your life in the hands of a bank that may or may not have been indicted. That is a very, very bad decision. You need a guardian. Who here has had surgery? All right, cool. Thank you, fellow people. I have 2 years on my knee, and as well as being a legal geek, I'm a giant baby, so I can remember that day like it was yesterday. They wheeled me into the surgery center. My heart was jacked. I was terrified. But what happened was I had people getting up in my face constantly. Doctors, nurses, anesthesiologists addressing themselves and speaking in jargon. We're going to do this, we're going to do that, we're going to do the other, and giving me papers and saying, what? Sign them. Who here like me didn't read them first? Another bold admission, ma'am. I'm not going to make fun of you twice. I am going to talk to you, though, because I saw that hand. Think about what you just did. You put your life in the hands of strangers. Really good chance you waived your right to sue or at least get a court hearing. It's a horrible decision. Where is your guardian? Who here has done some late-night shopping? Come on, you've played my favorite game. Gonna have a couple of drinks and gone on Amazon. Next day, what did drunk me buy sober me? I needed that fitness equipment, that pasta maker at 3 in the morning. Bad decision. Where's your guardians? Look what you've done. You signed things you shouldn't have signed. You bought things you shouldn't have bought. You did things you shouldn't have done. You need guardians. Who here has had a bad relationship and learned what a good one is? Who here has ever made a galactically bad judgment and said, oh, thank God, I'm never doing that again? And maybe even use that experience to give someone else advice on how to live their lives. Look what you've all done. You've all made horrible decisions. You've bought things you shouldn't have bought. You've signed things you shouldn't have signed. You've met and been with people who were bad for you. We all need guardians. Except you don't. Because those bad decisions you made you who you are. Sartre, eloquent as he is, was wrong. You are not your choices. You are your bad choices. You are the people you are because of the times you made mistakes and got up and learned from them and became stronger and wiser. We learn how not to get our hands burned by getting burned. We are better, stronger, smarter people because of the mistakes we've made. And when we mean well, and when we seek to protect people from making those same mistakes and gaining those same insights and experiences, are we not saying to people, although we mean well, we do not want you to be fully realized humans? We have to think about that. Like I said, I'm not here to say no guardianship, but I am here to say we need to consider carefully because the rights at stake are so dear. I'll give you one more example of what happens when you mean well and what the dangers are. Do me a favor, everyone. One more time, let's play together. Please think about the year 1995, particularly what things were like in the law for people with disabilities or older adults in the year 1995. As I look around and I see a couple of smirks, there were people in this room who were in grade school or possibly in utero in 1995. And to you, I say, from the bottom of my heart and on behalf of everyone else in this room, we hate you. Everyone else think. 1995 was 5 years after the ADA was passed. It was 4 years before the Olmsted decision. What that means is that in 1995, it was perfectly okay to say to a person with disabilities, I don't care what you can do. I don't care what you want. I don't care what your doctors say. You're going to live in an institution. You have no choice. In 1995, placement in a sheltered workshop was considered a preferred employment outcome. It was okay to say to people with disabilities, I don't care what your abilities are, I don't care what you want, I don't care what you need, you will work in this place making pennies on the hour, doing repetitive work. You have no choice. And people could brag about that. In 1995, we did not have Medicaid waivers like we have today, or supports or services. Now fast forward, 2018, 23 years later. One, community integration, the right to live in a community instead of an institution, is a Supreme Court protected right. Working in the community, competitive employment for real wages is now an expectation. Someday, I hope to say, it is a right. Right now, we have Medicaid waivers. We have supports and services. There is not a person in this room, I wager, who is not carrying in their pocket a computer more powerful than anything on a desktop in 1995. These are not just phones, and you know that. These connect us with people, people who can help us. This keeps track of my money and can link other people in to what's going on. This can keep track of my medical care. It can remind me to keep up with my medication and my schedules. I have a client who has a traumatic brain injury and diabetes, and often does not keep good track of her blood sugar. And that is something that would have landed her in an institution some time ago, probably in 1995. You know what she's got? She's got an app. She's got an app connected to her monitor. So when she has a blood sugar crisis, it texts her doctor and her sister so they can take steps to intervene. And she now lives quite well in the community. These are not just phones. These are tools. And that's what I mean. We have supports and services and technology and programs. Is it not true? Anybody dare to disagree with me when I say we have more ways to make more people more independent than ever before? Then answer this stupid question. Why have the number of people under guardianship tripled since 1995? Tripled. The estimated number is 500,000 in 1995, 1.5 million today. And people always think, well, it's because we're aging as a society. The evidence, such as it is, anecdotal and collected, is that the fastest growing population under guardianship are 18-year-olds with intellectual and developmental disabilities. 18-year-olds who, because someone means well, has been placed under a guardianship. And we know from studies, 90% of them have lost all of their rights. And the research on this is scary. This is what I mean about meaning well but without understanding. We know that people under overbroad or undue guardianships who lose their rights can suffer significant negative impacts on their health. They can live less long, feel less well, do less well, be involved less often. On the other hand, we know that people with more self-determination have demonstrably better qualities of life. And you know, these are the ones that really get me. Because the number one reason I hear for guardianship is the most well-meaning of all. I'm afraid my child will get hurt. I'm afraid my child will get abused. We have to look at the research on that too. There's a professor in New York named Ashita Kempka who's done a series of studies looking at the correlation between self-determination and safety. This is one of them. You know what Dr. Kempka did? She worked with a cohort of women with intellectual and developmental disabilities. If you don't know this, you should. Women with intellectual and developmental disabilities are exponentially more likely to be abused than any other population. Physically, sexually, emotionally. It's quite awful, actually. Well, she worked with a cohort of women with ID. And it was a classic experiment, you know, control group, experimental group. The control group lived their lives as they had. The experimental group was given a curriculum designed to increase their self-determination, to give them more control over their lives and make more choices. After they completed the curriculum, she tested both groups using a recognized test to review someone's ability to recognize abusive situations. You know what they found? The ones with more self-determination were not only better able to recognize abuse, better able to avoid it. They were safer. So I've told judges across this country, if we want to protect people, don't take away rights, empower them. And again, this is not rocket science. Are you not more protective over that which you know is yours? When you have a possession interest, when you have a real interest in your body and your life, you're going to protect it more. Now think about what happens to people with disabilities their entire lives. I had a great conversation yesterday. I told the person I was going to steal this, and I'm stealing it right now. When we have kids in daycare without disabilities, they are taught things like, what's a good touch, what's a bad touch, don't let stranger danger, don't let people get into your space. Kids with disabilities are touched all the time. They're told to give in to their people. They mean well. The people are going to be there. We're not empowering this. When we empower self-determination, we find greater safety. And I call this one the cherry on top of the sundae. The National Core Indicator Study. Anybody hear of it? I'm a geek, my favorite study. National Core Indicator Study was a study looking at the quality of life of people with intellectual and developmental disabilities, done in every state, or almost all of them, including here. What they did was they looked at people, they compared people with intellectual and developmental disabilities with other people with intellectual and developmental disabilities in an apples-to-apples way. They even used the old nomenclature, mild to mild, moderate to moderate. In other words, they looked at people with similar abilities and limitations and compared them to people of similar abilities and limitations over a number of variables because they wanted to see how variables impacted quality of life. One of the variables was whether or not the person had a guardian. What they found across the country is this: apples to apples amongst people with similar abilities and limitations. Those without guardians were more likely to work, to live independently, to have friends, to date and socialize in the community, and to practice the religion of their choice. Now, if we know, or at least strongly suspect this correlation, that what stands in between having that and not having that could well be whether or not one has a guardian, doesn't it mean we need to think carefully? Doesn't it mean that 2,500 years of a reflexive culture that says you must have a guardian needs to change? And that is what we're talking about. That's where I say, where do we go from here? Because if we know, and I hope I have proven this to you, that self-determination is a good thing and that losing it is a bad thing, it's not enough to say that we just need to leave people, just go off. I'm not going to get you a guardian. I'm going to leave you alone and go have your life. That's not what I'm saying. Because we need to realize something important. People need help. I mean, everyone needs help. But some people with disabilities need more help. Some older adults need more intensive help. Some people need specialized help. So this is the position I take. What we need to do is find a way to maximize self-determination, because that is directly correlated with quality of life, while at the same time finding ways to provide the supports and services people need so that they can be self-determined and exercise it. Sound good? Okay, so let me tell you a story. This face, her name's Jenny. Her name is Jenny Hatch. I met Jenny in 2013. Time flies. This is what you need to know about Jenny. She's a high school graduate, absolutely true. Jenny, at the time, shortly before I met her, had just completed her 5th anniversary at her job. A real job, not a supported job, nothing else, making regular wages, paying regular taxes. Jenny had her own apartment, not a group home, an apartment with a roommate that by all accounts, and I saw all the records, was kept beautifully. Jenny had a church she went to, people she liked, she was politically active, she was a volunteer. Here's what you need to know about Jenny. There's nothing special about Jenny. She had Down syndrome, doesn't make her special, doesn't make her an angel. All she had was a life, just like you. Jenny wanted to work, go home, go to church, see her friends. It's all she wanted. And it's all we can really ask for as citizens, right? And that's what she had at 29 years old until she got hit by a car. She got hit by a car and had to go to the hospital and found herself on the receiving end of a petition for guardianship filed by her mother and stepfather. And by the time I met her, Jenny had had a 3-hour hearing, roughly, and came out placed under what they called a temporary guardianship. Well, here's the thing about temporary guardianship. This is February 2013. This is when I met her. The hearing was in August of 2012. But when I met her, Jenny, who, remember, had her own apartment, was now in a segregated group home. A lovely home where she had her own room that happened to be behind barbed wire. Jenny, who had her own job for 5 years, was put to work in the sheltered workshop attached to the group home, where she, in her words, snapped snaps together, and when we saw the records after her case, had worked roughly full-time for 8 months and made less than $1,000. Jenny's cell phone was taken away, her laptop was taken away, her Facebook password was changed. If you wanted to see Jenny, you had to fill out a permission slip and give it to the guardians. Notice I said if you wanted. Jenny had no such rights. And if you filled out this permission slip, and if you don't believe me, I can show you where it's available online, you had to say what you wanted to do, when you wanted to see her, what you were going to do, and for how long, and you had to agree to the rules. The rules were on the back. If you flipped it over and looked at the rules, one of the rules was you were not allowed to talk to her about her guardianship or guardianship case. And if you violated the rules, you would lose your right to see her. You know why you weren't allowed to talk to her about her guardianship case? Because they said it upset her. Do you know why it upset her? It upset her because she wanted to go to her church and was told, no, we go to this church, get used to your new life. It upset her because she wanted to go back to work and she was told, no, you work here now, get used to your new life. She wanted to see her friends and was told, no, we do this, get used to your new life. So, the first time I met Jenny, I broke and entered. Room full of attorneys and professionals here, you know. Carry a briefcase, talk fast, you get anywhere you want, right? I walked in and said, I'm here to see Jenny. They said, she's right down there. I talked to her, I sat down, I said, Jenny, people wanted me to come talk to you. I would like to work with you. I'd like to be your attorney. Can I represent you? And she said yes. So I became Jenny's counsel at that point. And one of the first things I did was contact the attorney for the guardians. And I said, I'm representing Jenny. The case had gotten some attention. Let's ratchet things down and see if we can find a way here. But the first question I have to ask, and I need to know this, that whole permission slip thing doesn't apply to me, does it? And was told, yeah, it does. I said, I'm her attorney, and you're telling me I'm not allowed to talk to her about her case. And she said, and I was told, no, you can't. That's what the rule is. Now think for a moment about this. I know you're all shocked, but I want you to really consider the implications of this. Think about this. If Jenny was an axe murderer and was found with an axe and a head and was covered in person and was laughing, saying, I did it, ha, 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 you know what she'd have a right to do? Talk to her attorney about her case. But Jenny Hatch was not lucky enough to be an axe murderer. Instead, she was a person with Down syndrome in a temporary guardianship where apparently you have no right to talk to counsel. So realize this, the first time I went to court for Jenny Hatch, it was to ask for her to have the same rights as an axe murderer. It was to ask the court to give me permission just to talk to her about her case. And we had to brief it. We had to brief it and argue it. It was a contested hearing. Thank God the judge realized that people actually have the right to counsel, because I got to see her file then. And I asked the same thing you're asking. I see the faces. Why the hell did she have a guardian? Why did this person need a guardian? So I read the file. And first thing I saw was the order, which was basically cut and pasted. Long order. I'm not going to bore you with it, but I am going to show you the last paragraph. This is the last paragraph. The guardians have the power to make decisions about who sees her, what kind of support or health care she gets, what kind of day services, habilitation she gets, her education, her therapy, and where she lives. Jenny Hatch walked in a courtroom with all of the rights all of us have, walked out 3 hours later with that. Look at that. Does she have any rights left? Is Jenny Hatch even a citizen at this point after 3 hours? So, why? Well, it turns out that Jenny was examined by a psychologist who did what they call a capacity evaluation. And she did a capacity evaluation while Jenny was on Percocet, by the way. And that psychologist testified at the hearing. There was a transcript. And the bold is verbatim. When the psychologist was asked about Jenny's ability to live independently, well, if she had assistance, she could do that. What about her legal skills? She'd need assistance to read a legal document. What about her money management? Oh, she'd need assistance with a bank account. When the psychologist was asked what Jenny really needs, she's going to need assistance to make healthcare decisions. She will need someone to guide her and give her assistance. Well, what would be best for Jenny? What would be best for Jenny is to have people around her who support her and love her, who give her the assistance she needs. Okay, kept reading the file. Turns out that Jenny had signed a power of attorney when she was 18. And I mean a power of attorney. You pull them offline. So, interrogatory to the parents, if you think she can't make decisions, how the hell did she sign a power of attorney? How did she have the capacity to sign a power of attorney? Expecting that they would say something like, well, we thought she did, wanted to give her every chance, but it turns out she doesn't. Nope, they doubled down. Verbatim from their response. Jenny understood and signed that power of attorney because they explained it to her. She had an attorney, and oh, thank goodness, the attorney had time, asked her questions, got to know her abilities and limitations, let her ask questions, explained it, and at the bottom, based on this series of observations over several visits, the attorney decided, and we concurred, that Jenny was capable of understanding those documents. So you know what that means? I reviewed that, and I talked to Jenny at least twice a week. In fact, 2 days ago. They're right. They're all right. Jenny totally needs assistance. That psychologist, whatever you want to think about doing an evaluation on Percocet, she was right. Jenny totally needs help with medical issues. She really needs help with legal issues. She needs help in her day-to-day life. Undeniably. You know what that makes her? Human. Show of hands. Who here manages everything in their lives without help? Anyone? Because if there's a hand up, please see me at the break. I'm a mess. Jenny's a person. We all need help. We all always need help, and we had to find a way to explain that to the judge, that there is no sin in needing help. In fact, as you'll see, it's preferable. So we talked about supported decision-making. You want to know what supported decision-making is? There's your definition. Look at it, study it, love it. I've memorized it. You know, you can spit it right out. Supported decision-making is a recognized alternative to guardianship, where people with disabilities and older adults work with trusted friends, members, and professionals to help them understand the situations and choices they face so they make their own decisions without the need for a guardian. I did get it, right? Yeah, I wrote it. That's my name right there. That is perhaps the recognized definition of supported decision-making. Please feel free to look at it and appreciate it and then forget it because it's crap. That is pseudo-intellectual, insecure claptrap. Dr. Blank over there is my boss, and he's stuck with this. All those words. You know what supported decision-making is? How do you make decisions? What do you do? When the doctor speaks jargon and you say, please explain that in English. When the auto mechanic talks about your need for new muffler bearings and you go to your friend like I do and ask if I'm being overcharged for muffler bearings and my friend says, hey, stupid, there's no such thing as muffler bearings. We're getting the support we need to make the decisions we have to get. That's what supported decision-making is. It's simply finding people in your life who can help you when you have to make decisions. Here is my favorite supported decision-making story, fairly recent, and I love telling this. So I was working in Tennessee trying to get legal changes and policy changes to recognize more supported decision-making. And one of the legislators we met with was a judge, and is an awesome guy, but exactly what you would think a judge turned legislator from Tennessee is. Big guy, deep voice, intimidating from the moment you walk in. And he just couldn't wrap his head around supported decision-making. I don't understand. I did all my examples. I'm just not understanding. And then finally he stopped. He paused and he looked at me. And with this sonorous voice, he said, the widow of my law partner called me wanting to sell me his Corvette. Corvette. Good enough for the judge, good enough for me. And I like Corvettes. Didn't like the price. So I didn't know if I should buy that Corvette, but there's a guy in my neighborhood, everyone knows him, knows about cars. His name is Nunu. Hand to God, Nunu. So I called Nunu and asked him about the Corvette, and Nunu said, I know that make and model, that's too much. I said, thank you, Nunu, I won't buy the Corvette. And 10 minutes later, Nunu called back and said, maybe I should look at it. And the next day, Nunu called back and said, if you're not going to buy it for that price, I will. So I called the widow and said, I'd like to buy that Corvette. And he looked at me and said, Was that supported decision making? And I said, yes! Think about it, Judge. You didn't know what you needed to know to make your decision, but you knew. And you knew that knew what you needed, so you went to knew, and now that you went to knew, you know what knew knows. And because you know what knew knows, you can make the decision to buy the Corvette. You used supported decision making. My friends, I now call that the new bill. Here's the thing. Y'all got news in your life. You all got go-to people you go to. When you have a question that perhaps you're too close to about a personal relationship, you go to a friend and get advice. When you don't know, like me, about cars, you go to your friend who does. When you need a medical decision, maybe you know a doctor or a nurse or a friend. Maybe you just have people you want to bounce things off. You are using supported decision-making every day in your lives. As I said yesterday, I generally need a Sherpa and Siri just to find the places I speak. We all get help every day, but there is a critical difference. When people without disabilities do it, when you ask someone for help, you know what you're doing? You're making an informed decision. You're admitting where you need help, and you're getting the information you need. That's called an informed choice. We applaud that. Our supervisors say, talk to your colleagues. Our judges ask clerks to pull cases. Supported decision making, unless you're a person with disabilities. Because our culture for 2,500 years says that when a person with disabilities, when Jenny Hatch says, I don't get it, help me, that's seen as a sign of weakness. You don't know something, so you must not know anything. And then guardianship takes away everything. So here's the thing. Jenny had been using supported decision-making her whole life. Just hadn't called it that. You saw the power of attorney. She'd signed it with help. Her case manager's on the stand for a day, very pro-guardianship, by the way. And I asked, how did she sign her plan of care if she doesn't understand these things, her person-centered plan? And she said, oh, in Virginia, we use person-centered planning. We went through that page by page and explained it to her and gave her the chance to ask questions. And she could not go to the next page until she understood that page. She would initial the page, and at the last page, when we were sure she understood it, she signed it herself. Signing it herself was a big deal, because when we asked her parents how she could have consented to surgery if she doesn't understand things, they said the doctor was great. Jenny's needle phobic. Wasn't going to sign the consent, but the doctor got in front of her and explained it will be one needle. We need to do this to make you healthy. And when you wake up, the needle will be gone. You'll be able to walk better. And her parents said, Jenny, this has to be done. Trust me, this has to be done. And you know what? She agreed, and she signed it herself. Time and again, she signed it herself. An application for Medicaid. Ever seen one of those? Paratransit, rep payee, authorizations. They explained, she signed them. She had been using supported decision-making her whole life to make decisions every single day. 6 days of that. And we got down to, of course, closing argument, my favorite part of every trial. I'm sure that's a surprise. Closing argument was like it to be Al Pacino, in my head anyway. Pound the table, say things like, I'm out of order, and hoo-ah, and all that stuff. And I rant and I rave for an hour because I told Jenny I'm going to do this and we're going to lose. I was sure we were going to lose. In fact, we were planning to win on appeal. The transcripts had shown that the judge, like many, wasn't fully cognizant of what supported decision-making is and seemed to ask questions of my expert like, wouldn't it be okay to start in a group home and earn your way out, or earn your rights when you demonstrate you can exercise them? So I told her to be prepared. We're going to fight this. And she said, he's going to send me home. He said it every day. Every time we ever went to court, he's sending me home today. And I would say, Jenny, you keep believing that. So the judge hears arguments, says, I'll be back in 15 minutes, comes back in an hour. Always a bad sign. Starts reading, and hand to God, first 5 minutes of his order is all about why she needs a guardian. So lawyers in the room, you know this. You go into turbo lawyer mode, hand on the shoulder, rub the shoulder, tell your client to be strong. Tell we can do this. And Jenny says, he's sending me home. And I swear to you, the second after she said that, he said, however. Anybody like receiving however? Fortunately, we were on the right side of however, because the judge said, yeah, Jenny, I think you need a guardian. You haven't convinced me that you're ready to be in charge of your life in all facets of your life. Almost all of them. But you're going to have a guardian for two things, health decisions and safety decisions. Okay? Then he said, the guardians are not going to be your parents. See, I didn't tell you about Jim and Kelly. Jim Talbert and Kelly Morris were Jenny's employers. They told the story of how Jenny rode her bike to their shop, and she said, here's all the reasons why you should hire me. They didn't want to, but she convinced them, and they did. 5 years later, she's still working there. Well, Jenny has an accident, and she goes to the hospital, has to have surgery, and when she comes out, she can't go back to her apartment. She needs rehab. And her parents wouldn't take her in. No problem saying that on film. It was in the court record. You know who took her in? Her employers. Jim and Kelly brought her into their home, and they became a family. And when the guardianship case happened, you know what they did? Before I ever heard the name Jenny Hatch, they dropped about 50 grand on their own lawyer to make one argument. She doesn't need a guardian, but if she's got to have one, let it be us, because we're going to support her the way she wants to live. And Jenny sat with them, and Jenny made it clear, I want to live with Jim and Kelly. So the judge said, your guardians will be who you want, Jim and Kelly. And that guardianship sunsets in 1 year, and it did. Hard order. She's been living guardianship-free since August of 2014. Because the judge said to the guardians, Jim and Kelly, your job is not to make decisions for her or in her stead. Every guardian's job is to work with the person, here to help her be ready to make her own decisions using supported decision-making. First time a trial court ever used the phrase. And it got better after that. The judge said 2 more orders, guardians. 1, get her out of that group home and get her home immediately. And 2, get her back to work. I missed most of that because I was sobbing into her shoulder. Check the transcript, it was there. And so Jenny, in August of 2012, walked into a courtroom and 3 hours later walked out with no rights. That day, she got justice. She walked out of a courtroom with her rights back. And that picture was on the Washington Post. It goes with me until I die, because look at her face. That's the face of someone who was told, get used to your new life, and didn't. Remember how I said that there was nothing special about Jenny Hatch? One thing truly special about her, learned helplessness never kicked in. It never happened, and you know, that's scientifically speaking, that shouldn't have happened. But you know what? She said, every time I'm going home today, he's going to send me home. I will not give up. I want to live with Jim and Kelly. And she walked out of a courtroom after 9 months of litigation, 6 days of trial, after hearing everyone, from her parents, others in her life, saying all the things she can't do. She walked out with her life back. She got to go home. She got to live where she wanted to live, work where she wanted to work, do what she wanted to do, just like everyone else. That's the day Jenny got justice. And I look awesome. That is why I love this picture. I mean, check me out. They got her in focus and me in soft focus. So people will say, you really do kind of look like Al Pacino. And I'm like, hey, soft focus. Smear that Vaseline, baby. I am in for this. Okay. Begs the question why she got justice. Again, don't fall for the trap of saying she's awesome or she's an angel. Because there are a million people just since 1995 who've lost their rights. Probably just like her. You know what she had? She had help. Jim and Kelly spending their money and backing her. The media loved her. I can't imagine why. They covered her case from the beginning. National organizations, the ARC gave me a brief. The Bazelon Center for Mental Health gave me a brief. NAMI backed it. We had experts coming in, flying in at nothing or vastly reduced rates to this tiny courtroom in Newport News, Virginia. I'm telling you, basically from here back was the entire size of the courtroom. Coming to say that this person can utilize supported decision-making because she's done it. And just as importantly, she had a judge who listened and learned. She had a judge who went from earn your rights to your rights are yours. You know what that means? It means she got lucky. She got lucky. 1 million people under guardianship, 1 million Jennys, no justice. Why? Because we need to learn a lesson when it comes to guardianship and supported decision-making. Our rights, our justice, our self-determination should never depend upon our luck, on having people like Jim and Kelly willing to fight. No Jim and Kelly, no victory for Jenny, because we never hear about it. She just winds up another statistic in a permanent guardianship. No media calling attention to it, no freedom for Jenny. No judge willing to listen and put up with me, no Jenny. No freedom. She's just right back in that group home behind that barbed wire snapping snaps together. And that is something we need to get beyond. We need to stop cultural assumptions that it's just what happens. And I'm guilty of it. I worked for 14 years in the agency serving for people with disabilities in Virginia. You know what we used to ask when someone with an intellectual disability called? Who's your guardian? Not do you have one, but who? We naturally expected it. That needs to change. So where do we go? Here's your law. Here's what guardianships happen in Idaho. If you don't have a developmental disability, what happens is you get a guardian if you're incapacitated and that guardianship is necessary. You're incapacitated if you lack understanding or capacity to make decisions. Side note, if you're ever doing legislative drafting, please don't define a word by using the word. we get a kick out of it, but you're incapacitated if you lack capacity. Generally, if you can't make decisions, you're incapacitated. If you're incapacitated and it's necessary, you get a guardian. If you have developmental disabilities, if you have a developmental disability and you're unable to manage your financial resources or your health care, then a guardianship is appropriate. You are unable to do those things when it's shown that you can't do them, when you truly can't understand or make decisions. Not that you make bad decisions, notice. You have the same right to make bad decisions as others. It's only when you cannot make decisions. And in those situations, you can get a guardian. Well, think for a moment about capacity. Just work with me on capacity, because it's the biggest issue when it comes to guardianship. If you lack capacity, you may need a guardian. Well, anyone here think that capacity is a yes or no issue? That you either have it or you don't? Newsflash, none of us have capacity, unless you're a doctor, to manage your own medical care. We all go to the doctor. I go to the doctor. I have the flu. I beg my doctor for help. I'm a giant baby, remember? My doctor writes a script. I take the pill. I kiss her ring. I feel better. I have the capacity to take that pill naturally. But I don't know what erythromycin is. I don't know how to spell it. I don't know the difference between that and a Z-Pack. I don't know the side effects, but it's okay for me to do that because I trust my doctor. There was someone in a white coat with education who knows something I don't. I don't have capacity to drive my car because I can't fix it. I know I have friends, and I know I have a mechanic who can fix it when it comes down to it. So capacity is not, in very rare circumstances, a yes or no issue. Sometimes people definitely have capacity to do some things, and sometimes not others. Some people with disabilities, or some of us, may have capacity sometimes to do things, but not others. My capacity fluctuates based upon the hours of sleep and the number of Diet Cokes I've had. The answer to both of those is never enough. So capacity is not something you have or you don't. I think we can agree with that. It's something that depends upon the help we have, where we are. It's situation specific, yes? So when we ask this question about guardianship, we're going to ask a real serious one. If you can only manage or make decisions or do those things, if you have help, do you lack capacity? And I say, of course not. Because if it was any other answer, we'd all lack capacity, which means another important question. Because even if you're incapacitated, you still don't have a guardian unless it's necessary or unless it's truly proven you can't manage or meet your responsibilities with the help you have. So in other words, the smartest question to ask when we're considering guardianship is this one. What else have you tried? How can you know that someone is unable or cannot make decisions unless that person has been given assistance to see if they can do it? In the most extreme circumstances, of course, a person in a coma needs a guardian. I know. End-stage dementia, you probably need a guardian. But 97, I would say, % of the time, shouldn't we at least say, what have you tried to help this person make decisions? Because you can't know otherwise. You can't know if they're unable. Unable is a very strong word. So I say to this all the time, as a trial lawyer, as a geeky trial lawyer, my geeky trial lawyer dream is this, that at some point there's going to be an uncontested guardianship, and let's be honest, they almost always are. You know, the petitioners want it, the person doesn't want to go against their parents, the GAL is fine, whatever, and they hand up that boilerplate order like Jenny got, and there's no objection to it, and the judge looks at it and goes, before I sign this, can you give me a list of things that have been attempted to help this person, and let me know why they didn't work? And if they can't do that, case dismissed, or at best continued. We have an obligation factually to prove that a person cannot make decisions. And you can't do that just through an assumption 97% of the time. And that's not just me talking. That's the National Guardianship Association. You don't know them, you should. Guardianship.org, by the way. Guardianship Association, made up of guardians, by guardians, for guardians. They train guardians, they certify guardians, they have a code of ethics for guardians. There's nobody more invested in guardianship than the NGA. And this is what they say. Before guardianship, try something else. Try supported decision-making. Why? It might work. It might not. If it doesn't, guardianship's appropriate. If you've tried things, if nothing has worked and a person truly is unable, yeah, sure, guardianship is right, but the rights at stake, I hope I've shown you, the quality of life at stake is too important for us simply to assume it. We should try something else. And what the thing about supported decision-making, and I hope you realize you use it always in your life, it can help people with disabilities and older adults the same way it helps you. just to have someone to bounce ideas off of, just to weigh options. You know, it's like when I go to my buddy and go, I really, really want to buy a 2-seater convertible again. And he goes, hey, dummy, you got 2 kids. And I said, they can fight over the other seat. The one that loves me more can inherit it. And he goes, hey, you know, grow up. And I have to weigh my options and make sure that my decision is consistent with my values. I bought it, but I then was told to return it. But that's what we do with supported decision making. It helps us weigh our options and clarify our minds. It's what we're always told to do, and there's no one way to do it. If you're thinking to yourself right now, get to the point, hippie, and tell me how you do it. What's step 1? What's step 2? Where's the book? Where's the app? Good news, there isn't one. There can't be one. And I say that as a person writing a book. If we assume there is only one way to do supported decision making, we are admitting there is only one way to make decisions. And we know that's not true. Just like you, some people just need a listening ear, a friend, a new to bounce things off of. Some people like more formal arrangements. People with disabilities may like a power of attorney, and I'm going to show you POA language later. Or plans where we can say, I want you to help me with medical situations, so I'm deputizing you to come to the doctor with me so I can understand stuff, and I'm waiving HIPAA for you. I have issues with my budget. Very true. So I'm going to give you access to my bank statements. We're going to go over my budget every other month to make sure I'm not overspending. I am a mess when it comes to relationships, so I'm going to bounce stuff off you when I need to. That's supported decision making. Some people with disabilities even have more formal processes, like they're called micro boards or circles of support, a personal board of directors, where I meet with people once a month. We sit with my wise people and we bounce issues so that they can give me the best advice and I can make the best decisions. You know what? All of those are supported decision making, because all of them involve you helping me understand the things I need to understand so I can chart my own life course. Supported decision-making is something we all do. Because here's what I can tell you. I'm not going to tell you there's one way to do it, but I'm going to tell you that supported decision-making is a paradigm. It's a headspace. It's not a process. If we can make 3 commitments, you can be supported decision-making proponents. And it goes like this, and they're easy. If we can say that everyone has the rights to make choices to the maximum of their ability, that's easy, right? That's the Declaration of Independence. If you believe that we hold those truths to be self-evident, you believe that people have the right to make choices. 1. 2 is easier. I can say to you, can you help me with this, sir? Without you saying that must mean you can't do it and therefore lose the right to do it. That's easy because we do that every day. And the third one's the easiest still. There are as many ways to give and get help as there are people. There's always tools in the box. The first thing you try to empower someone may well not work. Not rocket science. How many times have you tried to do something new and have to go to step F because A through E didn't work? Keep trying. Something may work. Something may not. If things don't work, guardianship is appropriate, but we shouldn't jump to it because, remember how important self-determination is? We're doing studies, and we're finding that people who use supported decision-making are more likely to be self-determined. Again, not rocket science. If I work with you so I can make my own decisions instead of having you make them for me, I'm more in control of my life. And if we know that that's the key to a good life, and we do, doesn't it mean we should at least try? Because it's not new. The things I talk about are not vaporware. There are cases being decided now, but have been decided. Heck, there was a case in 1999 before anyone even used the words supported decision-making that terminated a guardianship because the person had a circle of support. You know, the Damaris L. case in New York was the first to use the words supported decision-making when they terminated a guardianship at the appellate level. Jenny's case was the first trial. The 2 under that were 2 other cases I had in D.C. There was a decision last week freeing a person from guardianship in Missouri because she could use supported decision-making, and yesterday in D.C. where an older adult was freed because they use supported decision-making. And you know, if you're not, the good news about SDM is you already have to use it if you're a lawyer, or you better be. I took a look at your ethical code. Rule 1.14, when you work with a client with disabilities, you must, as far as reasonably possible, maintain a normal client-lawyer relationship. Nice. Check the comments. The comments are awesome. Comment says the normal client-lawyer relationship occurs with the assumption that when I explain things to you, client, you get it and you can make decisions, even if you're under a disability. So my job as a lawyer, counselor at law, remember, is to explain things to you in a way that you understand so you can make decisions about your case. Doesn't that sound like supported decision-making? Well, the comments get even better because the client may want to have friends or family members in the room, and that doesn't violate confidentiality. Doesn't that sound like supported decision making? It's a paradigm. It's not a process. It is natural to attorneys. It is natural to professionals. We just need to wrap our head around the fact that people with disabilities are, in fact, people. We need to get past 2,500 years of culture that says otherwise. Because, again, comment 5 to a 1.14, we got to make sure our job is to minimize loss of autonomy, is to keep people in control to the best of their ability. And your law says the same thing. For people with developmental disabilities, the whole point of the guardianship system is to empower them to participate in their lives to the maximum extent possible to keep them in control of their lives. For people without developmental disabilities, same thing. The whole point is to empower them to be a maximal part of their lives. And here's the thing. We can do that. We're already charged to do that. As I said, nothing about this requires new laws. Nothing about it requires new regulations. What it requires is a new headspace. That we must begin with the assumption that people have the right to make choices, and it's our job to help them, support them, and maximize those opportunities. And opportunities to do that are all around us. And that is what I'm going to spend my next session talking about ways to incorporate supported decision making into what we already do and what people already do every day. Do we have time for a couple of questions, or should we break?
We got 15 minutes.
Oh, what can I answer? Sir?
So in Idaho, we've got guardianships, we've got conservatorships. And certainly much of what you had to say applies directly to conservatorships. But do you see any distinction in the analysis between guardianship and conservatorship?
Well, I didn't make the distinction because conservatorship, as you all know, is guardianship over money. Guardianship is guardianship over life. They really come down to the same thing, and they're covered roughly in the same section. So no, I don't see a distinction because I say the same thing. A conservatorship may well be appropriate, but we need to consider things first. Again, remember, I'm not here to say that there's never a time, but whether we're looking at money or life issues, we need to think carefully about what we're doing. And as I'm going to show you next session, we need to think about alternatives. Because especially when it comes to money, there's ways to do powers of attorney, to do joint accounts, to do methodologies that can keep people in control as much as they are able to, or hopefully maximally. So I look at conservatorship and guardianship as two sides of the same coin. Other questions? Ma'am?
You mentioned institutions earlier. Would you consider an assisted living for the elderly in institutions?
Depends on how you look at it, and it's like that's one of those ones where I was talking about large congregate care facilities. Of course, when we're talking about whether something is considered an institution, we're getting into Medicaid law. So there are certain times with a certain number of people at a certain level of care, it's considered to be what they call institutional or nursing home level of care. To me, it's a discussion we don't have to have right now, because our job should be to maximize opportunities in decision making wherever the person is. Other questions? Ma'am?
So the people around the person for supportive decision-making, if they are toxic and negative to that person, who is able to step in to protect the person from those people?
Yep, I get that a lot.
And like the car game where it's a supervision.
I get that a lot. And I wish, if you'd like, I can play you a comment of a judge answering that question. But here's how I look at it. Two things. One, when I am working with people on supported decision-making, when I am working with people in life, I realize something, is that if the goal is to ensure maximum independence, the goal is to ensure that people have as much as possible a life like me. So to start with, if there is nothing in place, those folks have the exact same protections I do. People here are mandated reporters. If someone sees me being abused or neglected, there is the police, there is APS, there's the Department of Health. Older adults and people with disabilities have even more protection. In Jenny's case, the judge raised that exact question, and I put witnesses on to show 9 agencies that could launch an investigation within 48 hours if abuse or neglect was expected. And I looked at the judge right in the eye and I said, "Can I get on your docket in 48 hours? And he just, poof, because he knew. So I say that people in this situation have all of the rights I have and even more protections. But when I said that in Nevada, Judge Francis Doherty, who was next to me, blew up. Because the question that was asked by a fellow judge. And Judge Doherty, in what I think is like one of the most eloquent things I've heard, said, I have been on the bench for 20 years. I have been on the domestic relations bench. I have been on the guardianship bench. I have never protected anybody. He said the court is a uniquely bad mechanism for protection because I never stop violence. We never protect. We react. We get it after the person has been hurt, and we say, do something about it. That is backward thinking, she said. What we need is more proactive action. We need better supports, better services. We need more prosecution of abusers. We need more education and more self-determination to help people be more aware of their rights. And she said, and I wish I had the exact quote in my head, but essentially what she said is, to take away rights in the name of protection by people who have done nothing to deserve losing their rights, that's a sin. So, is there possibility for harm? Yep. I can't guarantee that I won't be harmed. We'll talk more about that later. But as a practical matter, no pun intended, in your materials is something that the American Bar Association put out called the Practical Guide, the steps that they urge attorneys, and I say everyone, to consider before guardianship. And one of them is considering the people in the person's life. T, does the person have a team in place? Person doesn't have a team, identify people who could be part of the team. And C, concerns. Because if there are people who could be toxic, if there are people who could be harmful, it is on us to take steps. The Code of Ethics requires that. Advise the person, take steps, file a protective order, go to APS, do whatever we can to protect the person from being hurt. I agree 100%. But like Judge Doherty said, except in the most extreme circumstances, that does not justify losing rights. The rights that we have are too important. I mean, consider this if you're a criminal attorney. Why do you have right to counsel? The right to counsel is because your liberty is at stake. You could go to jail. You could lose fundamental rights. You could lose the right to associate with people. You can lose the right to vote. You can lose the right to do basic things in your life. Now ask yourself what happens with a guardianship. Same liberty interest. Those rights are too important to reflexively say something bad might happen and therefore we should lose rights. Can I have other questions? Judge?
I just want to add something to that because the Guardianship Conservatorship Committee added a guardian complaint process that's pretty accessible and easy. If people have to turn to can fill out that complaint, it goes right to the court. We'll also have the guardianship monitoring coordinators, and they can be a very sort of central piece in dealing with toxicity in the relationship. And we've relaxed ex parte rules, in fact, under Rule 54, so that kind of information can come to the judge and get sent out to all the interested parties. But don't hesitate bringing the case back to the court. That's one of the things that's really important about what we want to talk about. We heard Judge Peterson up in Coeur d'Alene talk about it as if we just flip a switch and all of a sudden the guardianship is done. We enter the order and it's done. But this is a continuing process of re-examination, and when we're having trouble between the person who's under the guardianship and the guardian, that's something that the court can address. So don't hesitate in bringing things back to the court. I mean, in this state, I would say, relative to a lot of other states, court hearings are pretty quick to get on the calendar, maybe not in Ada County, but elsewhere in the state, and we can at least have a discussion. I would even just call it a status hearing, where we have a conversation about what's going on, what can we do to fix it, or what do we need to change in the guardianship.
And the court process, I know what you said is, what about people who aren't under the supervision of the court? Here's, and
We're doing supported decision making, so you have no authority over people in their lives.
and yet, the court's authority is there, because if there is a supported decision-making relationship, or any relationship, let's support decision-making out, in my familial relationship, if you see or suspect that I am being abused or neglected, you have the same power to do the same things for a person with disabilities as anyone else. And that means the court's always there. You can file a new petition. You can file a petition. I tell parents all the time, guardianship's not going anywhere. It's always going to be there. Why should we rush? But if we do see toxicity, abuse, or neglect that we can't stop, maybe guardianship is appropriate. Maybe APS, and I've lectured to APS on this, maybe the use of temporary guardianships to put things right is useful. We don't have to slap someone in a lifetime guardianship if what we need to do is help someone get somewhere in their life. So there's always options. To me, I'm comfortable saying we should start with an assumption of rights and capacity and try to build that. But if we know that and we see evidence that it's not there, we should take appropriate action. It's just that's secondary. Does it put people at risk? Yep, same risk I'm at. I am at risk. Life is about risk. We showed before all of the risky, bad decisions you made. Nobody had to go to court for you. You learned. Does it mean that you can get hurt? Yeah, but that is part of living. And we will never get to a place, pardon my sermonizing, we will never get to a place where there is equal rights until there is equal opportunities, including an equal opportunity to make a bad choice or get hurt. And I believe that with every fiber of my being, and I think it is consistent with every law I know, including, as Judge will show you, Idaho's laws. Other questions we can answer? Ma'am?
How long have you seen this shift taking in other states? I mean, because it is a real shift from, people are hearing at 12 years old that we start thinking about guardianship, and at 15 start thinking of pediatricians and psychologists and schools, and then, and then you go and you talk to the attorneys come talk to you, and they scare you, and they need guardianship, and then, your guardian ad litem, might read the report, the judge might agree with, we agonize as the committees that look at all these here, we agonize over our report and what we limit a guardianship to and how long we limit it to. And nobody's, since we're not represented in court, nobody's objecting to the original petition, and so these guardianships are getting granted anyway. And so we're just, we feel some real frustration.
Of course.
And I just wonder how long we expect this, is it 10 years from now? This cultural change that needs to happen?
The answer is too long. I will say that things have come farther, faster with regard to supported decision making than anything I've ever seen. Jenny's case was 2014, and it struck a nerve. That's why. I mean, she's cute, and she is eloquent, and she had a great case. And it got attention. People magazine wrote about her. She was on TV. And yes, that spurred interest, because post-Jenny, we have seen at least an explosion at upper levels. We have new states with new state laws ever since Hatch. We have new procedures in place. We have new preferred practices. And yet, as you know, and I'm going to talk about in my next session, it hadn't really trickled down. So what we need to do, people in this room, is talk and make sure that when a case comes to court, we insist upon a proper standard. We need to push back. I'll tell this later, but the number one referral source for guardianship is what? Anybody want to guess? Teachers. We did a study. I expected to find parents or lawyers, but nationally, number one with a bullet, educational professionals. We are hearing when you're getting guardianship. That's something that we can talk about. We can educate. We can talk to people. We can advocate. And person by person, I call it changing the world because it's a cliche, but it's right. Every time you empower somebody and you convince a teacher, every time you convince a judge, every time a person keeps their rights, it makes it easier for the next one.
Every high school I go to, they're on board, immediately on board.
Yep.
Go talk to them, they're on board. But
You have to, yeah, it's, and it's hard, man, it's hard to know what the right thing is and have people still be stuck in a culture loop that's 2,500 years old. But you know what, as the song goes, the only way to beat the darkness is you got to kick it till it bleeds daylight. And that's what we do. That's what advocates do. It's what lawyers do. We rail at the darkness, we kick at the darkness until light comes through. And every time you help a kid, light comes through, and that kid probably adds up to 3 more. And then just do the math. Ma'am?
Yeah, and what she said, I feel like it really does start with a conversation with the attorneys first, because their families are spending so much money,
Yeah.
Initially, and then they come through the process, and we offer these, alternatives, and then they're invested all of this money.
With no offense to anyone in this room, I try to educate the lawyers and judges last. You're going to see in a sec, my goal is to educate at the front end. Because I think guardianship can be appropriate, but the cases that come to the lawyers and judges should be only the ones that are appropriate or the ones that are close on the borderline. If we can get people early, if we can maximize self-determination, and that means parents and teachers and counselors and case managers, doctors, the people who see people every day, what are the end users of supported decision-making, then we obviate, those cases that just culturally would go to guardianship. So that's what I want to do, is I want to close the front door. By the time it gets to the lawyer or the judge, there's a good chance something bad happened. It really is. There's a good chance that bad things happened, perhaps because of systemic failure, and then they're seeing guardianship as the only option. Well, we need to get those options out there early, and that's exactly what I'll be focusing on in the next session. I think we have time for one more, sir.
Yeah, we're starting a review of new C&G provisions in the portfolio code. Those are much more insistent on supported decision.
Oh, yeah.
Other situations, so that may be a partial answer if that gets adopted here.
The ABA has been a very strong proponent. Erica Wood, if you haven't heard the name, you should know it. She's brilliant. She's written on this for decades. But the ABA, who put out Practical, they just did a statement calling for all states to review their laws to empower supported decision-making. And with any luck, within the next year, the Uniform Guardianship Act will include supported decision-making provisions. So you find your allies. There are people out there. And let's take a break, and we'll come back in a few.